This is it, the final video in the American History 2 AP curriculum. We're going to talk about modern rights, the 26th Amendment, and then some court cases. Gideon versus Wainwright, Escobedo versus Illinois, Miranda versus Arizona, and Roe v. Wade. Let's do it. We made it here finally, folks. Those are the cases and amendments we're going to talk about. The Vietnam War is going on, so we've got some lyrics from the song Eve of Destruction. The Eastern world, it is exploding, violence flaring, bullets loading. You're old enough to kill, but not for voting. The voting age was 21 going into the Vietnam War. So that means if you were under 21, you couldn't vote for the government. And the government are the ones that decide whether we go to war or not. 11,465 men were killed in action and were under 20 years old. So every one of those people that died for the country were not old enough to vote to decide whether we should even go to war at all. So the 26th Amendment to the U.S. Constitution will lower the voting age to 18. Good, cool. Now you can go die and you can vote at the same time. Great, but whatever. How do we add amendments to the Constitution? Well, it's really difficult. Over 10,000 amendments to the U.S. Constitution have failed. 2/3 of Congress must vote yes. And then 3/4 of the state legislatures must vote yes. And then if you are able to overcome those two massive hurdles, you can add an amendment to the Constitution. It's not that hard when it's a really big deal. Like, hey, we've got a lot of men and women that are going and dying to protect this country, and they're not even old enough to vote whether we should go to this war or not. So we lower the voting age to 18. Now we're going to talk about some court cases in the activist court. The Supreme Court's main power, according to, well, not necessarily the Constitution, but according to Marbury versus Madison, is that they review the laws and determine whether they're constitutional or not. They review the actions of the executive branch and determine whether those actions are constitutional or not. They basically say whether things can or cannot happen. That's their biggest power. In the 50s and 60s, during the civil rights period, the courts were really all about protecting the rights, making sure that our rights were protected. They were very activist in making sure that laws were being followed or laws were being interpreted in a way that protects the citizens' rights. Brown versus the board is an example. So we have an activist court. The problem with an activist court, now, some people believe in an activist court. They should be active and they should be making our country better. Others believe that's not what the Constitution said. The Constitution does not say that the Supreme Court is supposed to make our lives better or make laws or determine or make rights exist. That's the job of the legislative branch to write laws and the executive branch to enforce those laws. When you have an activist court, you're pretty much having a court system that's writing laws and making up the rules. That's supposed to be the power of the legislative branch. Others say, it's the Constitution. You can stretch it. You can read it any way you want. But as long as you get the results that you want or the results that you need, and that's fine when you have an activist court that's fighting for your beliefs. What happens when you have an activist court that's making decisions that you don't agree with? Maybe it's best to allow the legislative branch, the branch that we have elected and can re-elect. You can't change the Supreme Court. You can change the legislative branch. And if people are making laws that we don't agree with, we can change them. When Supreme Court is doing this, the American people really have very little say. So again, people like the activist court. They like the Supreme Court when they're making decisions that they like. That's the problem you run into. So Gideon versus Wainwright. Gideon is basically a drunk, a troublemaker. That doesn't mean he did what he did. Either way, someone breaks into a pool hall and they find Wainwright and they accuse him of it and they take him to court. And while he's in court, he says, hey, the Sixth Amendment says I get a lawyer. I need a lawyer to defend myself. And the court in Florida says, no, that's only for death penalty cases. That's only in case of murder do we give you a lawyer. You don't get a lawyer. So he's found guilty, goes to jail. While in jail, he studies the law. He files an appeal. The appeal goes all the way to the Supreme Court, which is an activist court. And he says, look, I was denied counsel. I didn't get my Sixth Amendment right protected. I didn't have a lawyer and I lost. I need a redo with a lawyer. And the Supreme Court agrees. Hey, if you're charged with a felony, you get an attorney. It's not just death penalty cases. It's not only cases where you're facing the death penalty. It's any felony, you get the right to counsel according to the Constitution, the way that we interpret it. The way that this activist court in the 60s interpreted the Constitution was that no. Everyone accused of a felony gets a lawyer. Gideon did not get that lawyer. He gets to go free. What does the Sixth Amendment actually say? Well, let's skip down. It's just a paragraph to the part that matters. The Sixth Amendment of the U.S. Constitution from 1787, well, actually, this would have been 1791 when the Bill of Rights was added, to have the assistance of counsel for his defense. That is all it says. It says that he can have a lawyer. Well, go buy a lawyer. The government doesn't necessarily have to provide a lawyer for you. It doesn't say that everyone gets a free lawyer for every single thing they're accused of. That's not what the Constitution says. But an activist court who's rewriting the rules and writing the laws can interpret it however they want based on constitutional documents, based on other court readings. They don't just simply read this. They take other things into consideration. They take other events. They take other writing of the founding fathers to come up with this idea. And ultimately, this activist court decides, no, you get free lawyers. And so that's the way that it is today. Escobedo versus Illinois in 1964, Danny Escobedo is accused of murder. And just like you've seen in the cop movies and TV shows and Law and Order, they're giving him a hard time. They're grilling him, confess. He's like, I want my lawyer. I want a lawyer. And they keep hounded him for 14 hours. His lawyer shows up and they say, no, you can't come in. Eventually, they beat him down. They break him down. I don't know if they actually beat him, but they wear him down and he confesses to it. And he is found guilty with that confession. Well, he will write an appeal. It'll go to the Supreme Court and activist court. They will review the case and say, look, man, you denied him due process. The Sixth Amendment says he has the right to an attorney, to counsel. You denied him that right. You denied him due process. You can't do that. He was set free. I think a lot of people would agree with most of these decisions. The process, maybe not, but the end result, of course. 1966, Miranda versus Arizona. Ernesto Miranda is accused of kidnapping and rape. This is not breaking into a pool hall. This is not a false claim that he murdered someone. He's accused of kidnapping and rape. So this is going to come down to the Fifth Amendment. Now, Ernesto Miranda should have known the Fifth Amendment says you don't have to tell on yourself. In the Fifth Amendment, you have the right that you do not have to incriminate yourself. You can remain silent. You don't have to confess. The Sixth Amendment also says in the Constitution, you have the right to a lawyer. Again, they bring him in, they're giving him a hard time, and he confesses. He writes down that he did it. He didn't know he had a Fifth Amendment right, that he didn't have to incriminate himself, that he didn't have to tell on himself, that he could just shut up. He didn't know what the Sixth Amendment was. He didn't know that he had the right to a lawyer. He did not know his rights. Oh, I don't know. I didn't know. And so he'll appeal after being found guilty, and the judicial process, the judicial review from Marbury versus Madison, the Supreme Court, and the activist court will say, look, you denied him due process. You denied him his Fifth Amendment right. You denied him his Sixth Amendment right. You got to give those to the rights of the accused. The rights of the accused. He's been accused, whether you like him or not, whether he's guilty or not, he, as an American citizen, still has a Fifth Amendment right. He has a Sixth Amendment right. He does not have to incriminate himself. He does not have to sit there without a lawyer. You have to protect those rights, whether you agree with him or not. And they're saying, wait, look, it's not our fault that he doesn't know his rights. It's not our fault that he slept in social studies class. It's not our fault that he didn't pick up a book and learn about the Constitution. It's not our fault. Well, no, yeah, it is. It's the 60s. We're an activist court. And during this time, the police are abusing citizens. So guess what? Instead of putting the burden on the citizen, we, the activist court, is going to say, here's the rules moving forward. It's no longer the responsibility of a citizen to know their rights. It's no longer a responsibility to take care of yourself. The government is going to do it for you. They must read your rights. And we call this the Miranda rights. Sweet, he's free, right? Awesome. Well, no, not so fast, Mr. Ernesto Miranda. We're just going to give you a new trial, and we're going to throw out the confession. You confessed because you didn't know your rights. So we're telling you your rights, and we're going to take that confession, and they cannot use that during your court case. Oh, okay. But they can use other evidence and prove that, yeah, you did kidnap someone, and yeah, you did rape somebody, and yeah, you are guilty. Sorry, but not sorry. You did those things, and you've got to be punished. And we're kind of sorry about taking your rights away. And this was a long process to get to this point, but hey, here we are. But the bigger thing is now we have the Miranda rights, and if you've seen any cop show or any TV show, you know that they read you your rights because the activist court assumes that we as American citizens are too stupid to know our own rights. And maybe they're probably right. So anytime that you are held under arrest, they will read you your Miranda rights just so you know your rights so that later on you can't say, well, I didn't know. No, you knew because we read them to you. If you didn't study in class, no big deal because I'm going to read them to you again. But if you don't pay attention this time while I'm arresting you, then too bad, so sad. That's the way it works. probably should learn your Miranda rights. Last one. Roe v. Wade, Roe versus Wade in 1973. Before this court case and court ruling, abortion was illegal in most states. I'm not getting into abortion, whether you're pro-life or pro-choice. Let's just talk about the court case. Let's just talk about the facts. And you need, for a second, just separate what you view in terms of abortion. Let's just go through how this came about, Roe v. Wade. So a victim of a rape wants an abortion. She lives in Texas. In Texas, at this time, abortion is illegal. She will then sue for the right to an abortion. And they will argue on the grounds of the Ninth Amendment that she has the right to an abortion. If you read the Ninth Amendment, it says there are other rights that may exist aside from the ones explicitly mentioned in the Constitution. The Founding Fathers knew they cannot write everything down in the Constitution. The document would be 1,000,000 pages long. They can't tell you you have the right to eat sausage on Tuesday. They can't come up with the right that says you can wear pants on your head. They don't want to write down every single right because it's impossible. So the Ninth Amendment says, look, we can't write every right down. So there are other rights that aren't explicitly listed. And in this case, Jane Roe will argue that, hey, one of those rights is the right to an abortion, a right to my own body. This court case will go to the Supreme Court, and abortion is illegal. Well, she actually loses, but they'll go to the Supreme Court. The Supreme Court will look at it, and they'll rule 7-2 that no, it's your body. You have the choice. But this decision is not based on the Ninth Amendment that other rights are not written down. The ruling of the Supreme Court will be based on the Fourth Amendment, which is the right to privacy. The government has no business in terms of your body or the operations that are happening within your. Again, people say, but wait a second, what about the rights of the baby? What about the rights? Look, I'm not going into that, whether pro-choice or pro-life. I'm telling you what the activist court ruled. And what this court ruled was that based on the Fourth Amendment, the government really shouldn't be involved with you and your doctor in the decisions that are made. I'm not going to get into the arguments, but it's the Fourth Amendment, not the Ninth Amendment, where they come up with this decision. But the strange thing about that is it's still illegal for a second trimester. Wait, so it's not illegal during the first 3 months based on privacy. So then it really should be legal the second trimester or the third trimester. I mean, if it's based on privacy, that the government shouldn't have any involvement in this based on the Fourth Amendment, then why does that change with time? Well, that's the way they ruled, and abortion is illegal in most circumstances in second and third trimester. But wait a second, how's it? I'm not going to get into that. You're going to want to talk to some judicial scholars, some constitutional experts, and maybe some pro-choice people and some pro-life activists to find out the details of that. But nonetheless, Roe versus Wade, here's how the decision came about. There was the background. The Fourth Amendment says that the government has to respect your privacy and cannot get involved in that. That's it. Hopefully those rights will help. Hopefully you don't ever have to worry about those rights someday. And thanks for joining me for over 17 hours of American history videos. It's been a wild ride.